misrepresentation and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is an agent or a law enforcement agency of a federal, state, province, county, city, township, agency present?
No way.
This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hands, say your name, and state your position. And could everybody mute up so there's no back sound there? Thank you. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hands, say your name, and state your position. Perfect. One last time. This meeting is private. Bearing false witness and misrepresentation and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Looks like we're all clear, so I'll open up our meeting with a small prayer. O Holy Father, bless our meeting with eyes to see and ears to hear. This meeting and info being presented with an open heart, and open and caring and compassionate heart for all our fellow brothers and sisters, as it shall be done. Take it away, Glenn.
Well, I guess I better unmute first.
That's great.
I just want to say thank you, Lori, for doing such a great job getting that all going there. What I did, I think I went and presented how I paid the filing fee at the last meeting last week, but I haven't even checked with the court, but I figured I'd go ahead and tender some rice. And so this is my affidavit of tender. And there's also a cover letter to go with it.
Nice. Good job.
So I thought this would be a good thing to talk about tonight.
Yes, because the currency is getting out of control everywhere these days. So
there you go. Well, and they want me to tender fake money, and they're holding up my case because of it. Although I don't know. I mean, they might have responded. I haven't even called them up or gone down to check it out. I was going to go down on Thursday, and then I decided just to go ahead and do this. And so this is the tender. And so affidavit of tender, it's 2 pages? So
is this what your friend used regarding that fine or something that he had?
Yeah, he paid a $15,000 debt, and what happened is not only did the debt go away, but it was to pay for 10 years of probation, and the probation went away too. So we've actually tendered, we went and tendered. There's one friend of ours that's down there, and he's got a $50,000 bond. And so we tendered 50,000 grains of rice. And so we've done it with some other, but we haven't. We're kind of curious to see what happens. That's why I did this, because I'm curious to see what happens. Anyways, so affidavit of tender. I, GlennWinningham, House of Fern, a living man of flesh and blood, being of lawful age and sound mind, do hereby affirm under penalty of perjury the following. I'm affiant this matter with personal knowledge of the facts stated herein, and I'm competent to testify thereto. On December 4th, 2025, I tendered 600 grains of uncooked long grain white rice as full and complete payment for the alleged $405 filing fee on behalf of the Pope's GlennWinningham Fern Trust for case number 424 CV 1299 PBJ. This tender is made in good faith as lawful specie, equivalent dollar for dollar under the Pope's House Joint Resolution 192 of June 5th, 1933, codified at the Pope's 31 U.S.C. 5118, which suspends the gold standard and allows discharge of obligations in any lawful medium. The Pope's owned and operated United States has failed to specify the required specie for payment in violation of the Pope's HJR 192, the Pope's Texas Constitution, Article 1, Section 17, and the Pope's Uniform Commercial Code 3-603. Rice as a commodity of intrinsic value serves as an equitable tender historically recognized in commercial law. This tender discharges the debt in full, and refusal constitutes dishonor under the Pope's UCC 3-505, waiving the claim. Further affiant saith not, I declare under penalty of perjury the foregoing is true and correct, executed on December 4th, and GlennWinningham, House of Fern, fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to be representing the Pope's minor estate, sovereign living soul, holder of the office of the people, ban on the land properly belonging to the Republic of Texas, with full responsibility for my actions under the laws of Yahweh as found in the Holy Bible, with the postal address of, and that's got the postal address. And there's the notary statement. So it's notarized, and then this is the cover letter. So non-domestic mail, care of 6340 Lake Worth Boulevard, Fort Worth, Texas, rural free delivery, 76135, non-domestic mail without the Pope's United States. Certified mail, 7018. They haven't received it yet, by the way. It's supposed to get there Monday. Anyways, Karen Mitchell, Clerk, United States District Court for the Northern District of Texas, Fort Worth Division, 501 West 10th Street, Fort Worth, Texas, 76102. Tender of payment in lawful specie for $405 alleged filing fee for case number 425 CV 1299 PBJ, pursuant to House Joint Resolution 192 of 1933, demand for acceptance and discharge of debt. To Karen Mitchell and all authorized agents, GlennWinningham, House of Fern, a living man of flesh and blood, on behalf of Pope's GlennWinningham Fern Trust, do hereby tender this lawful payment and full discharge of the alleged $405 filing fee for case number 425 CV 1299 P-BJ. This tender is made under duress, rendering any further residue obligations moot. Pursuant to the Pope's House Joint Resolution 192, passed by the Pope's United States Congress on June 5th, 1933, codified under the Pope's 31 U.S.C. 5118, the Pope's United States abrogated the gold clause and discharged all obligations in legal tender or equivalent value, suspending the requirement for payment in gold or silver specie. The Pope's HJR 192 explicitly states that obligations may be discharged dollar for dollar in any lawful medium, and no creditor, including governmental entities, may demand payment in a specified form of currency or specie without violating the suspension of the gold standard, as affirmed in cases such as Norman versus Baltimore, an Ohio Railroad Company, 294 U.S. 240, 1935, and Perry versus United States, 294 U.S. 330, 1935. This resolution renders demands for Federal Reserve notes or other fiat as the sole medium unlawful, and they are not backed by specie or equate to private credit instruments. The Pope's United States, just a second here, my phone was ringing and it's, I got to silence it. There we go. The Pope's United States, as a corporate entity operating under color of law, has failed to comply with to specify the required specie, implying an unlawful fiat-only demand for payment of this alleged debt in violation of the Pope's HJR 192 and the Pope's Texas Constitution, Article 1, Section 17, prohibiting impairment of contracts and requiring just compensation, under the Pope's Texas Business and Commerce Code 3-603 and the Pope's Uniform Commercial Code 3-603. A tender of payment in good faith must be accepted if it is in a medium of value equivalent to the debt, and refusal constitutes a waiver of the claim. I hereby tender at least 405 grains of rice, each grain of tangible redeemable unit of value, approximately 1 grain per dollar as equitable measure, as rice is a historical and lawful commodity, tender per ancient commercial law, precedents like the Code of Hammurabi and the modern UCC equivalents, as full satisfaction of the Pope's $405 filing fee. This tender is made in lawful specie, as rice constitutes a barterable good of intrinsic value, and no statute mandates fiat currency. Enclosed herewith or available upon demand is 405 grains of uncooked long grain white rice, weighed and certified at least 405 grains, totaling at least 10 grams, tendered in a sealed container for verification. Exhibit A, affidavit of tender, attesting to the good faith and equivalence of this payment. Acceptance of this tender discharges the debt in full with prejudice and stops the Pope's United States from further collection efforts, including liens, offsets, or referrals to collections. Refusal or non-response within 10 days of receipt shall constitute dishonor under the Pope's UCC-3-505, waiver of the claim and grounds for sanctions, including a counterclaim for harassment under Pope's Texas Penal Code 42.07. I reserve all rights under the Pope's UCC 1-308 and demand a receipt of acceptance or rejection in writing, specifying the exact specie required, if any, to cure any alleged deficiency. Failure to accept this lawful tender will result in immediate filing of a notice of default, affidavit of non-response, and commercial lien against court officials responsible pursuant to the Pope's Texas Property Code 53.001, etc., and federal precedents under the Pope's HJR 192. Govern yourself accordingly. Tendered under duress and without prejudice and without recourse to my unalienable rights. GlennWinningham, House of Ferns, sui juris, fails to be dead or lost at sea, never has been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to be representing the Pope's minor estate, sovereign living soul, holder over the office of the people, a man on the land properly belonging to the Republic of Texas, with full responsibility for my actions under the laws of Yahweh as found in the Holy Bible, with a postal address of General Post Office, zip code exempt, 6340 Lake Worth Boulevard, etc., etc. Certificate of service. I certify that the original of this letter and enclosures was served upon Karen Mitchell via certified mail, return receipt requested on December 4th, 2025, by certified mail, and enclosures at least 405 grains of rice in a sealed container, and Exhibit A, affidavit of tender. And that's it. That's all I did. And so we'll see. I haven't got an answer yet. But so we'll see.
What did the notary say when you got it notarized?
Well, they don't. They got nothing to say about it. So they didn't say anything. They're not allowed to read it, quite frankly.
Just
They're
verifying
just
everything.
witnessing my signature. All the notary wanted to know is what's the title of the document, and there's nothing wrong with that. They asked for the title of the document, so they went to the front page and they saw the title and they wrote it down. That's all that matters.
Yeah, that's all they want for their books. That's what my notary did too. Good.
Yeah. So, anyways, so that's it. I don't know. Is there anything else we want to talk about? I can't think of anything else I want to talk about. I mean, we could go through my latest amended war crimes complaint. It hasn't been filed, and it won't be filed until I get the other one served, and they've responded at least once, and everybody's responded at least once, because then that might affect how I respond to some of this stuff. So there's going to be changes to it for sure. Somebody have something to say?
No, I just said, of course, you want to make sure that that's settled and dealt with first.
Yeah. Well, yeah, exactly. Once it's been served and they respond, I get one amended one for free, and so I want to make the amended one a good one, because I might not get a second one. Matter of fact, I wouldn't count on. I tried to do a second one in the last court case, and they wouldn't accept it, and so I had to go with just the amended one. So.
So clarify what this is pertaining to: the arrest in New Mexico or the foreclosure?
Foreclosure? What foreclosure?
Or the land,
Yeah, the land theft. Yeah, no, that one's in the Supreme Court right now. So we're waiting to see what happens with that one. This one is about the arrest in New Mexico.
yeah, I'd like to see it if you want to reveal it. But don't post it, of course, yet until you're complete with it.
I can read it, go through quickly,
Mm-hmm.
and we can cover it really quick.
So when did you first start putting this on paper? As soon as, like
I've
in
actually
September?
when I filed the other one, I wanted to get it filed, knowing that I could do an amended one anyways. But I wanted to get it filed so I could start working on, because I knew it was going to take a while to get the summonses. I got to fight with them over the filing fee. I'm not going to pay the filing fee, and so I'm having to fight with them over it. And so now I sent the notice of objection that we talked about last week, and I filed that, and I went down there on Monday, and they hadn't responded, which I'm surprised. I'm not surprised that they hadn't, and they might have responded by now. I haven't received anything. I checked the mail today, and there's nothing in the mail. So if they sent something out, it hasn't made it to my mailbox yet. And so I filed this. That's why I filed this this tender, this affidavit of tender. And that's going to get to them Monday. So we'll see what happens there. Anyways, so we can go through. This is my amended war crimes complaint. This is not the final version. This is there's going to be some changes. I really don't know, what changes might happen, but we'll breeze through stuff that like I've added a few people. Let's see here. I added Elizabeth Beach, William Bosworth, Thomas Wilder. I added them. I added Bill Wayburn. He's the Tarrant County Sheriff. I added, and I'm going to add I've actually ordered a police report with the New Mexico State Police, and so I'm hoping that I'll be able to get some names to add there too, and that might take a little bit. And then John Kerry, I added him, former U.S. Secretary of State. Now, a lot of this stuff is the same, but I added in this right here. The demandant is not dead or lost at sea. The demandant has never been dead or lost at sea. The demandant is not a surety or accommodation party for the Pope's minor estate, and will never be a surety or accommodation party or for the Pope's minor estate because of his Christian's religious beliefs. The demandant is not representing the Pope's minor estate, which is necromancy and satanic and a violation of Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion. The rest of this stuff, some of this other stuff was here already. I added this in. All the wrongdoers named herein are tyrants, engaged in tyranny. And I thought that would be a good slant, because now I call him a tyrant all throughout the document, Anyways, tyranny is the exercise of power beyond right. This is by John Locke. 2 Treatises of Government, Book 2, Chapter 18, Section 199 and 201. So it's coming from a pretty credible source. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put in the hands for the government of the people and the preservation of their properties is applied to other ends, is made use of to impoverish, harass, subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. I think that nails it pretty good. Anyways, a lot of this stuff was there already. I think that was...
Yeah, I like that statement. That's very powerful.
Yeah. I'm not sure if this was there. It says here, the court has jurisdiction because the wrongdoers named herein are depriving the demandant and the people of the Republic of Texas of U.S. constitutionally, federally protected rights, including but not limited to the right to pursue happiness, the right to get compensation for labor, the right to engage in constitutionally protected activities like conduct a common law court, the right to seek a redress of grievances, the right to exhaust administrative remedies, the right to due process of law, the right to life, liberty, and the pursuit of happiness, as found in the Organic Law of the Declaration of Independence, 1776, and all of these rights are required to be protected by the United States equally for everyone under the territory under Article 9 of the 1933 Montevideo Convention on the Rights and Duties of States. And the jurisdiction of states within the limits of the national territory applies to all the inhabitants. Nationals and foreigners are under the same protection of the law, and the national authorities and the foreigners may not claim rights other than or more extensive than those of the nationals. And then this is actually one of the reasons, I didn't bring this particular issue up, but I've always said that that's why Trump has to build a wall, okay? Because once they're on our territory, they are entitled to all the protections of the Constitution, and this is just confirming that. And so that's why Trump had to build a wall. That is part of the treaty collection and entered into force December 26, 1934 at 49 Stat 3097, and the U.S. Army State of Texas dictatorship and military occupation is illegal and unconstitutional under Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States. And you could make the same argument in Canada, actually. The contracting states definitely establish a rule for their conduct, the precise obligation not to recognize territorial acquisitions or special advantages which have been obtained by force. Excuse me. Whether this consists in the employment of arms and threatening diplomatic representatives or any other effective coercive measure. The territory of a state is inviolable and may not be the objective of military occupation, nor of other measures of force imposed by another state directly or indirectly or any motive whatever, even temporarily. and that's Article 11, which requires that the state of the territory of a state is inviolable and may not be the objection of military occupation. The evidence shows that wrongdoers in this case are tyrants, operating under color of law to violate the demandant's right to self-determination to be a Texas national, as well as the right of the people of the Republic of Texas's right to self-determination to be Texas nationals, guaranteed by the International Covenant on Civil and Political Rights, as well as the 1933 Montevideo Convention on the Rights and Duties of States, both of which have been acceded to as treaty law by the U.S. Senate. Overview. The demandant will show the court that the state of Texas is a military dictatorship, fictitious overlay over the Republic of Texas. The Republic of Texas, recognized by Andrew Jackson, still exists. In the early 1990s, some of the people of Texas discovered this and brought the Republic of Texas out of abeyance, or dormancy, by forming a provisional government of the Republic of Texas and started holding elections for the Republic of Texas and have been peacefully holding elections ever since. The evidence will show that the wrongdoers have engaged in repeated, systematic, and continuous violation of the demandant's common law rights under color of law, with slander, defamations, assaults, false arrests, kidnappings, false imprisonments since 2007, and the free exercise of his rights to engage in U.S. constitutionally protected activity under color of law. The evidence will show that the wrongdoers are taking reprisals against the demandant and the people of the Republic of Texas for our religious beliefs to subject us to their satanic religious ceremony with their fraud, deception, necromancy, and idolatry. The evidence will show that the wrongdoers have engaged in a malicious prosecution. See Thompson versus Clark. That's a 2022 court case. Unlawfully arrested the demandant with a fake warrant, kidnapped the demandant, falsely imprisoned the demandant as part of their war crimes agenda in retaliation for anyone who exercises their right to self-determination as a Texas national. The demandant alleges that some of these wrongdoers named herein have forged the demandant's signature onto an IRS 1099-A form and bid performance and payment bonds in order to embezzle money from the Pope's minor estate Treasury Direct account, and the demandant will hire a forensic accountant to prove it. The demandant alleges that some of these wrongdoers named herein have engaged in aggravated identity theft, accounting fraud. That should be accounting fraud. Concealment, securities fraud, tax evasion, embezzlement, and forgery, and the demandant will hire a forensic accountant to prove it. The demandant alleges that under 26 U.S.C. 7201, 26 U.S.C. 7206, and 26 U.S.C. 676. Actually, I want to add another one in there, too. Let me find something here. Oh, here it is.
I wanted to ask, why aren't you mentioning that they're breaking gap rules? Does that not apply in the U.S.? Like, that's the only thing I have up here, and you know where.
Well, that's interesting that you asked that. I could put that in. Let's put it in.
Yeah, I want you to read my write-up. It's nowhere near engineer worthy, but I can send it to you on Telegram and we can read it. It's quite similar to what you got right now, so won't be going too far off topic, but I have more to add once you're done reading this.
Have failed or produce certified certified GAAP,
General accounting. Acceptable principles.
well, we could put that in there.
Accepted. That's the full.
Let's do that. Maybe I'll do this, in fact. Certified GAAP accounting. And in order to conceal the accounting with the intent to defraud the demandant, and the demandant will hire a forensic accountant to prove it. There we go. We added it in. It's there. I see it there. Anyways, all the wrongdoers herein are being sued in their private capacity. I think that was already there. That was already there. That was already there. That's already there. That was already there. That was already there. Did we go through this before? I don't know if we went through this before even. I think we did, though. President Andrew Jackson officially recognized the Republic of Texas March 3rd, 1837, which was also recognized by France December 25th, 1839, and other nations, including Belgium and the United Kingdom. And the demandant has visited the former embassy of the Republic of Texas in Paris, France, that is now being used as a hotel. I think we talked about this before. The fact that the Republic of Texas existed is beyond dispute. And there is no definition of how many people are required to constitute a nation or state. And all the inhabitants of the territory properly included within and rightfully belonging to the Republic of Texas are entitled to the same protection of the law. And that's Article 9 of the Montevideo Convention. The jurisdiction of states within the limits of national territory applies to all inhabitants, nationals and foreigners, are under the same protection of the law, and the national authorities and the foreigners may not claim rights other or more extensive than those of the nationals. The state of Texas joined the Confederacy and Union in 1845. In the year 1845, the state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union, 1781, as evidenced by the Act of Congress at 9 Stat 1, and still exists as evidenced by HGR 1, dated 29 December 1845. The territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the State of Texas, on an equal footing with the original states in all respects whatever, with a Republican form of government as found in the Act of Congress, December 29, 1845, at 9 Stat 1. And this is the preamble to the Act. Says the state of Texas admitted in the present session of Congress into the Confederacy and Union. And it says, and this is HGR 1, 29 December 1845, 9 Stat 108, whereas Congress of the United States by joint resolution approves the March the 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the State of Texas with a Republican form of government. And it's admitted, resolved, that's admitted into the Union on an equal footing with the original states in all respects whatever. That means in the original under the Articles of Confederation. And I go and explain why. It says, because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted, but was shelved. The state of Texas was created under the Articles of Confederation and Perpetual Union in 1781 under Article 9. And Article 9 of the Articles of Confederation says Canada ceding to this confederation and joining in the measures of the United States shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed to by 9 states. So that's why they only did a House Joint Resolution, which means a House Joint Resolution is all that was needed. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas, the territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced with the state of Texas, and the Republic of Texas still existed in abeyance or dormancy. It seems to the demandant that for the state of Texas to join the Confederacy under the Articles of Confederation 1781 with a House Joint Resolution is perfectly fine. But the current Constitution was in place in 1845. Article 4, Section 3, Clause 1 requires, but no new state may be formed or erected within the jurisdiction of any other state, which is what happened. So in the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum to conduct business and could not conduct business. And on the 15th of April of 1861, Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 at 12 Stat 1258, and they've been operating under executive authority ever since. The southern states that walked out of Congress became the Confederate States of America, and the war between the states was started, which eventually ended with an armistice, a ceasefire only. All of those people are now dead, and there's never been a treaty of peace. The state of Texas was one of the Confederate States of America, and a technical state of war still exists between the United States and the Confederate States of America because there's been no treaty of peace. But there was an armistice, a ceasefire only. In the year 1863, Lincoln asked Harvard law professor Francis Lieber to write the law of war for the U.S. Army, which became known as the Lieber Code, but is actually designated General Orders 100. All of which is now included in the United States Law of War Manual that is now a book about 4 inches thick and is part of the international law or the law of nations. The current state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. Now, for those of you in Canada, what do you think those military police are doing? The ones called the Royal Canadian Mounted Police. Didn't they start like in 1867? That's a hostile army. Think about it. And under the Montevideo Convention, that's unconstitutional. The martial law continues to this day under Article 2, General Orders 100, Lieber Code. Martial law does not cease during a hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in a treaty of peace concluding the war. Because there has been no special proclamations by the Commander-in-Chief, who would be the President of the United States, and there is no treaty of peace. In the year 1871, while operating under executive authority, Congress authorized a municipal corporation to operate in the District of Columbia at 16 Stat 419, which is talked about in the dissenting opinion of Downs versus Bidwell, U.S. Supreme Court, 1901, as the second national government that is maintained by Congress outside and independently of that instrument. That's the Constitution, folks. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. That's dissenting opinion of Justice Marshall Harlan in the case Downs versus Bidwell, 1901.
I checked, Glenn, and Canada never was at the Montevideo Convention because they were at war with England.
Oh, well,
So
let
I
me
was
see here.
wondering.
Let me see if I can find that.
So I wanted to know if I could use that.
Yeah, that's a good question. Let's see. I thought that Canada had, but you never know. I've been wrong before. I was wrong one time when I thought I was wrong, but I was actually right.
Well, it kind of cross references because they are supposed to adhere to the Libra Code, which they don't adhere to. Well, one law for me and another for thee kind of thing, right? But the Libra Code was established in the Montevideo Convention, is my understanding.
The Libra Code?
Yeah, that's where it was formulated.
The Libra Code was written by Francis Lieber. No, you're right. It's not listed here. Wow.
Yeah, I just checked on it this Monday, so I know it didn't slip my memory.
Well, I've got it here, and it's not listed as one of the states that have, but Canada could, but that's interesting. United States has Guatemala, Honduras, Uruguay, Brazil, Ecuador, Dominican Republic, Paraguay, Nicaragua, Mexico, Colombia, Chile, Panama, Venezuela, Bolivia, Cuba, and Peru. So, yeah, Canada's not listed there. That's very interesting. So, okay, I'll let you have that one. If you want, I can email it to you, or you can probably just download it online.
Yeah, I have.
Okay.
I went over that
Okay.
document actually earlier this week.
Okay. Okay, I'll let you have that one. Good catch.
I wanted to use it, so that's why I had to, just refresh on what was actually confirmed at that convention, right?
Right. Just trying to make this as big as I can to make it as easy to see. Yeah, that's a little better. Okay. So, and the military police are conspiring together with their bar member handlers to work for that second national government. An officer who acts in violation of the Constitution ceases to represent the government in violation of their oaths to support and defend the supreme law of the land, Article 1, Article 6, Clause 2. The 1933 Montevideo Convention on the Rights and Duties of States was ratified by the United States as a treaty and entered into force December 26, 1934 at 49 Stat 3097, which requires that recognition is irrevocable and unconditional, but it doesn't say that here, does it? In Article 6 and under Article 8, no state has the right to interfere in internal or external affairs of another state, and all the inhabitants of a territory are required to be protected by the government equally under Article 9, the 1933 Montevideo Convention on the Rights and Duties of States, and the military occupation is unconstitutional and illegal under Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States, which requires that the territory of a state is inviolable and may not be the subject of military occupation. Further evidence of the tyranny and war crimes being engaged in by these military police in conspiracy with their bar member handlers to threaten, coerce, injure, and intimidate the people of the Republic of Texas in the free exercise of our rights to engage in U.S. constitutionally protected activities of common law courts and petition the government for the military government for redress of grievances in support of our right to self-determination, our right to determine our own political status as Texas nationals, violating the International Covenant on Civil and Political Rights as a treaty entering into force September 8, 1992. Under HJR 1, dated 29 December 1845 and 9 Stat 108, the state of Texas is required to have a Republican form of government, and it's impossible for a military government operating under martial law to be a Republican form of government because the military government is a dictatorship, as evidenced by Article 3, General Orders 100, Libre Code. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and the domestic administration and government of the occupied place or territory, and in the substitution of military rule and force for the same, as well as in the dictation, that's dictatorship, folks, as well as in the dictation of general laws as far as military necessity requires the suspension, substitution, or dictation. The commander of the forces will proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. And of course they're going to do that. They don't want you to figure out that you're under martial law because rebellions happen when that shit happens. Because the Republican form of government requires law of the land, natural law and common law, and political power to be in the hands of we the people, and a symbolic military government called a democracy, with all state of Texas employees, including all the wrongdoers named herein, being federal personnel as required by the Roman civil codes 5 U.S.C. 552A 13, which is anyone with a social security number, and this is what it says. The term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. So they're all federal personnel. For the Pope's 1871 municipal corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. So it's a municipal corporation. It's municipal law. That exists today is the second national government talked about in the dissenting opinion of Downs versus Bidwell, that is maintained by Congress outside and independently of that instrument, the Constitution, and is the Pope's military dictatorship, plenary power, because the boundaries of the District of Columbia expand for the purpose of regulating its citizens wherever they go throughout the states of the Union. And this is National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948, U.S. Supreme Court. And through their plenary power, that's dictatorship, folks, nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And the United States has failed to provide a Republican form of government as required by Article 4, Section 4. The United States shall guarantee to every state in this Union a Republican form of government, except that the Republic of Texas is that Republican form of government, but is being maliciously attacked by the military police in conspiracy with their handlers and the Pope's private bar guild. The Republic of Texas brought out of abeyance. After the war between the states and its armistice, many years have passed, and all those involved on both sides are now dead. And in the early 1990s, some of the people of Texas, after reviewing the Act of Congress 9 Stat 1 and resolutions HJR 8, March 5th, 1845 at 5 Stat 797, HJR 1, 29 December 1845 at 9 Stat 108 of the U.S. Congress and other historical evidence, discovered that the Republic of Texas was in abeyance, which is dormancy and is an entirely different entity from the state of Texas, and the Texas territory is properly included within and rightfully belonging to the Republic of Texas, and brought the Republic of Texas out of abeyance and organized a provisional government of the Republic of Texas and peacefully held elections and have been peacefully holding elections ever since to peacefully provide for common law remedies for the people of Texas. The Republic of Texas is a foreign government. The Republic of Texas is a group of men and women in the territory properly included within and rightfully belonging to the Republic of Texas, trying to peacefully bring common law remedies to the people of Texas as a Republican form of government. Because the state of Texas is a military government operating exclusively under martial law as a military dictatorship and can never be a Republican form of government. Treaty of Peace. Even though the demandant has resigned as a senator because of the threats, terrorism, intimidation, coercion, and injuries by the wrongdoers named herein, the demandant can say with some authority after being involved with the Republic of Texas government for almost 20 years that the people of the Republic of Texas would very much like to enter into a treaty of peace with the United States to bring to an end the war between the states as far as Texas is concerned. We believe it would be good for everybody, and maybe other states formerly part of the Confederate States of America would like to do the same. It would be very good to bring us that dark chapter of our history to a final conclusion. Case dismissed for lack of jurisdiction. In the year 1995, the Supreme Court of Texas dismissed a case involving the people of the Republic of Texas for lack of jurisdiction. Case 95-1002, styled In Re, the people of the Republic of Texas, by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District, et al., evidencing that they know they have no authority over the people of the Republic of Texas. Right to self-determination and political status. The U.S. Congress and the President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, and is now the supreme law of the land as a treaty under Article 6, Clause 2. And we, the people of the Republic of Texas, have the right to self-determination and the right to determine our own political status as Texas nationals. Therefore, we're engaged in a U.S. constitutionally protected activity, and the military police are conspiring together with their bar member handlers to threaten, coerce, intimidate, and injure we, the people of the Republic of Texas, in the free exercise of our right to self-determination, to determine our own political status as Texas nationals, for our Republican form of government, guaranteed under Article 4, Section 4, since the Popes owned and operated the United States has failed to do so. The demandant has never in his life breached the peace, but the military police tyrants breach the peace on a routine basis with their unlawful false arrests, which are assaults, false imprisonments, kidnappings, as described herein, and they've slandered and defamed the demandant repeatedly in countless ways, as described herein, and demonstrate that they want the demandant and anybody who thinks they have common law rights dead, because they're doing exactly what Lieutenant General Michael Flynn, U.S. Army retired, says the U.S. Army does to an enemy in his book, The Citizen's Guide to Fifth-Generation Warfare, Section 1 and Section 3-3. First, they polarize the enemy. Second, they tribalize the enemy. Third, they dehumanize the enemy. And fourth, they kill the enemy, which is their objective for the demandant. The tyrants have slandered the demandant, defamed the demandant, dehumanized the demandant, calling him a sovereign citizen terrorist for their bar member handlers, to the point his own sons and daughters do not talk to the demandant for fear of being slandered and defamed themselves. Another war crime, and these military police and their bar member handlers have demonstrated they intend to continue to slander and defame to create terrorists so they can shed some innocent blood for their handlers and justify the demandant's murder until the demandant does turn up dead for their handlers. The military police tyrants and their bar member handler tyrants and the Joint Terrorism Task Force claim that the people that they label as sovereign citizens do not think the law applies to them, and that is entirely false and evidence of their low intelligence threats, lies, terrorism, and calumny they're peddling to generate business for themselves as part of their agenda to polarize, then tribalize, then dehumanize the demandant and the people of the Republic of Texas in preparation for the final and fourth and final step, murder. The U.S. Constitution is the supreme law of the land equals common law. The truth of the matter is that the Constitution under Article 6, Clause 2 is the supreme law of the land in America, and the phrase law of the land is talking about common law. The principle that no person shall be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 9, confirmed on the 19th day of June, 1215, declared no freeman shall be taken or imprisoned or seized or outlawed or exiled in any wise destroyed, nor shall we go upon him nor send upon him but by the lawful judgment of his peers and by the law of the land. It has been said that the principle was known before Magna Carta, that it was originally designed to secure the subject against arbitrary action of the crown and to place him under the protection of the law. It's settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in the common law. When first adopted, the Magna Carta, the phrase law of the land had reference to the common law and is a fundamental rule in the common law, and that's Book 16, American Jurisprudence, Constitutional Law, Section 543. And the common law is the law of the land, has always been here before the government was here. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. That's long before. And was here before the government was, and the military government is required to step aside when we the people step forward, ex parte Milligan, and common laws everywhere above the high water mark and after the first bridge on any navigable river, except for the District of Columbia under Article 1, Section 8, Clauses 17 and 18. And any federal enclaves as affirmed by Section 14 of the Organic Law, the Northwest Ordinance of the 1787 that was passed just 3 months prior to the U.S. Constitution being ratified by the demandant's fourth great uncle, among others, as well as affirmed by the Judiciary Act of 1789 at 1 Stat 73, saving to suitors in all cases the right to common law remedy where the common law is competent to give it, and the Judicial Code of 1911, saving to suitors in all cases the right to a common law remedy where the common law is competent to give it, at 36 Stat 1161, Section 256, Part 3. All of which is evidence that the military police and their bar member handlers intended to perjure their oaths to the supreme law of the land because they are government employees being federal personnel as required by their Roman civil codes, 552, Title 5, USC 552 A13, which is anyone with a social security number. And I read that already. Are busy working for the 1871 Municipal Corporation at 12 Stat 419 under Roman canon law, which is the second national government maintained by Congress outside and independently of that instrument, the Constitution, talked about by Justice Marshall Harlan in the dissenting opinion of Downs versus Bidwell, and which they are bringing into Texas with the Pope's minor estate and the Commerce Clause, Article 1, Section 8, Clause 3. And that's that National Mutual Insurance Company versus Tidewater District of Columbia, in violation of Article 1, Section 8, Clause 17, not exceeding 10 miles square. They're using the Commerce Clause to bring the District of Columbia dictatorship outside a maximum of 10 miles square. The truth of the matter is that a common law proper name is never spelt in all block capital letters. Therefore, the name GlennWinningham Fern in all block capital letters is a derogation of common law and the fiction of law, as described herein in the minor estate at 31 CFR 363.6. The truth of the matter is that in the year 1213, the tyrant Pope Innocent III coerced King John into giving the Pope his kingdoms. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Pope. And renting them back with the concessions to the Pope of 1213. We will establish a perpetual obligation and concession, and we will establish that from the proper and special revenues of our aforesaid kingdoms, and for all the service and customs which we ought to render for them, saving all times the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the Feast of St. Michael, 500 marks, and at Easter, 500 marks. 700, namely, for the Kingdom of England, 300 for the Kingdom of Ireland. The truth of the matter is that the minor estate, sestike usufruct, created was created with the Sestike V Act of 1666 by the tyrant popes, owned and operated Crown of the United Kingdom. Yet still is found difficult to set bounds to ecclesiastical papal ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but the nominal fiefs to the use of the religious houses. That's the Pope, the Vatican, thus distinguishing between the possession and the use. That's usufruct. And receiving the actual profits, while a season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to a sestike use for the rents and emoluments of the estate. And it is to these inventions that our practitioners are indebted for the introduction of uses, which is usufructs and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And brought into the United States with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be the sestike use. It's 1617 at 31 Stat 1432, now codified at 31 CFR 363.6. Because of the necromancy, the sestike use is usufruct, people are presumed dead. At Chapter 3, absence of 7 years, at 31 Stat 1230, where it says, presumption of death. He shall be presumed dead in any case where his death shall come in question unless proof shall be made that he was alive within that time, which is now called the minor estate, is an entity because an entity includes the estate of a living person such as an incompetent or a minor. And that's 31 CFR 363.6. And a minor can be anyone over the age of 18 who has failed to take control of the securities in their treasury direct account. The term minor is used to refer to an individual who's attained 18 years, who has attained 18 years but has not yet taken control of securities contained in his or her minor account, which is a fiction of law, which falls under Roman canon law, was invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. And that's Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. Fictions of law are necromancy and satanic. That's Deuteronomy 18:10-12, King James Version, and puts you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square. And everything in the Code of Federal Regulations, including the minor estate, is government property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And the demandant may have an interest in the minor estate, but the demandant wants nothing to do with it because it was created by fraud and deception and is necromancy and satanic. As described herein, the truth of the matter is that it's a badge of slavery because it is property belonging to the United States, because a slave is a thing that is owned as property, and because the military police are using the minor estate and the Commerce Clause, Article 1, Section 8, Clause 3, to bring the District of Columbia plenary jurisdiction, dictatorship outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. And this is that National Mutual Insurance Company. Because their minor estate, 31 CFR 363.6, is a type of a trust, and a trust is property and a thing and has no rights and falls under Roman canon law, and the military police are all U.S. citizens of the District of Columbia as required by the Roman civil codes for their 1871 municipal corporation. Because there's two national governments, They intend to make sure the demandant is subjected to their District of Columbia military prisons, which is exactly what has already happened as described herein with their warrants that failed to be authentic, and the District of Columbia Roman law so-called courts. Therefore, whether they enslave the demandant or kill the demandant resisting the slavery, either way, it's a win-win-win scenario for the military police tyrants and their tyrant handlers. The demandant and the Republic of Texas. In 2004, the demandant heard about the Republic of Texas from some Rice McLeod videos. Rice McLeod was at the time Attorney General for the Republic of Texas. The demandant got involved with the Republic of Texas government in 2007 when the president recommended the demandant run for Congress, which he did. When the demandant was elected to a seat in Congress, the president recommended the demandant run for Speaker of the House of Representatives, which the demandant did and was Speaker for about 18 months. While Speaker of the House of Representatives, on several occasions, the demandant was approached about starting a militia, and he told them on every occasion if they wanted to start a militia, they were free to do so. But the Republic of Texas did not want to appear to be a threat of any kind. Therefore, the Republic of Texas would not be doing that, but might be interested in having an emergency response team to give aid to local governments in the event of a natural disaster or local emergency. In the year 2009, the demandant got a contract in White Plains, New York, and resigned from the House of Representatives and went to New York. While in New York, the president of the Republic of Texas contacted the demandant about approaching the Russian Federation about a treaty of peace and recognition. They sent the demandant a commission as a charge d'affaires, but they never did give the demandant a final go-ahead to contact the Russian embassy. Because the demandant was commissioned as a charge d'affaires, which is similar to an ambassador for the Republic of Texas, the demandant is entitled to lifetime diplomatic immunity under international law. A true copy of the commission is attached here to it, Exhibit 1, all of which is incorporated herein by reference in its entirety. In an effort to exhaust administrative remedies and exercise his Article 1 and Amendment right to petition the government for redress of grievances, on 14th of June 2010, the demandant served by registered mail, a notice and demand designed to take away their presumptions taken under martial law on Michael T. Tooley, Chief Administrator of the Montana Highway Patrol. And the first paragraph says, I accept your oath of office, and saying among other things that the demandant has a right to resist an unlawful arrest with lethal force if necessary. See the U.S. versus Schooner Amistad, which was a slave ship where the slaves overpowered their captors and killed all of them except for 2, because they did not know how to sail. And they demanded to be taken to Africa. The U.S. Navy found them and brought them to the United States, and they were charged with murder. And the U.S. Supreme Court dismissed the murder charges and ordered them returned to Africa. A true copy of the Michael Tooley notice and demand, together with proof of service, is attached here too at Exhibit 2, all of which is incorporated herein by reference in its entirety. It was first discovered, Texas DPS slander and defamation. It was first discovered when a friend of the demandant's son found in an Arizona post office the Texas DPS intelligence bulletin full of hearsay information obtained with illegal search and seizures in violation of Article 4 Amendment, issued on 7 September 2010, saying that their minor estate was armed and dangerous and used the Montana Highway Patrol notice and demand and the Republic of Texas as justification and retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, and self-determine Texas national status. The demandant started getting harassed at airports and boarding crossings, getting selected for extra screening. In the year 2012, the demandant returned to Texas and was involved with the Republic of Texas House of Representatives and then 2 terms in the Senate. On 3 January 2013, the demandant was unlawfully arrested, assaulted, kidnapped and falsely imprisoned, and physically dragged into a U.S. Border Patrol office on Interstate Highway 10, about 10 miles west of Sierra Blanca, Texas, for about a half an hour before being told he could leave. The demandant filed a lawsuit, 413 CV 576, which was dismissed by Samara Cummings as frivolous on 13th of August 2013. The demandant filed a lawsuit in Texas courts, and the tyrant Janet Napolitano, the director of Homeland Security, refused to accept service, and there was no address to effect service at the border thugs, and it was eventually dismissed for failure to prosecute because of failure to effect service on some of the respondents. In the year 2013, the demandant missed a flight from Calgary, Alberta, because of U.S. customs delays. Assault, kidnapping, this is 57. I think I'm going to go up and add Janet Napolitano. Matter of fact, I am sure I will. Let's see, where am I going to add that bitch?
No.
Let's put her there. Janet.
Did you say bitch or witch?
I said bitch. Anyways, 57. Let's go back there.
Do you own that book about the military manuals?
I have a copy, yeah.
Is it expensive? Did you get it on Amazon or something?
You can get it on eBay. I bought it on eBay. It's about $60. You'll find stuff about military police, about law enforcement officers. They're military police. In the year 2013, the demandant missed a flight from Calgary, Alberta because of U.S. customs delays, assault, kidnapping, false imprisonment, and a friendly, sympathetic U.S. customs official told the demandant to get a U.S. Marshal's FOIA request, which he did. And when it eventually came in the next year, 2014, it was over 500 pages redacted of mostly notice and demands that had been sent to government officials accepting their oaths of office, together with the Texas Department of Public Safety Intelligence Bulletin, full of inadmissible hearsay information obtained with illegal search and seizures in violation of Article 4th Amendment, saying that the minor estate is armed and dangerous, true copy of which is attached here to it, Exhibit 3, all of which is incorporated herein by reference in its entirety. Texas DPS slander and defamation. In the fall of 2013, the demandant was arrested at the border with Canada in Coutts, Alberta for smuggling because they'd unlawfully searched his 34-foot travel trailer and found some pepper spray and a high-capacity magazine, more than 5 rounds capacity in communist Canada, over a lookout synopsis full of hearsay information that said the demandant was armed and dangerous and a sovereign citizen, evidencing that the Texas Department of Public Safety was unlawfully and maliciously sharing their defamatory, slanderous intelligence bulletin full of hearsay information obtained in a legal search and seizure in violation of Article 4 Amendment with their Five Eyes Alliance communist foreign enemy tyrant buddies. In retaliation for the demandant exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, and self-determined Texas national status. They held the demandant in their torture chamber, which was about 40 degrees Fahrenheit. You could see her breath for over 24 hours with just a short-sleeve shirt on and no coat or jacket. They took all that shit away. In support of the Texas DPS war crimes agenda, a true copy of the lookout synopsis is attached here too as Exhibit 4, all of which is incorporated herein by reference in its entirety. Texas DPS slander and defamation at U.S. Consulate, Calgary, Canada. In early 2014, the demandant was at a U.S. consulate in Calgary, Canada to get a passport. They decided to take a lunch break and after business. Let me think here. Let me I like to put in stuff like that because these judges like to, if you don't tell them exactly what it is, who knows what they're going to presume it is. Anyways, don't get me going. They're not interested in justice. In early part of the year 2014, the demandant was at a U.S. consulate in Calgary, Canada to get a passport, and they decided to take a lunch break. And after business was finished, the demandant went downstairs, and the Calgary military police were waiting and arrested the demandant. And the Calgary military police told him that they got a phone call from the U.S. consulate tyrants, evidencing more Five Eyes alliance sharing of their malicious intelligence bulletin full of the Texas DPS slander and defamation with their communist foreign enemy buddies in conspiracy with the Montana Highway Patrol in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The demandants spent 82s in jail for fake smuggling charges in support of their war crimes agenda to take reprisals for political beliefs, further evidence of the intent of tyrant John Kerry, U.S. Secretary of State, to conspire with tyrant communist foreign enemies to engage in war crimes in retaliation for exercising U.S. constitutionally protected right to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The Kangaroo Court in Communist Canada had ordered the minor estate to undergo a mental evaluation like the tyrant communists do to their political dissidents by putting them into mental institutions to perform forced medical experiments on them, just like they're doing to Bonnie Strait right now. So after being released from their jail, the demandant immediately left the country, has not been back. On February 14, 2015, Valentine's Day, the Republic of Texas Congress meeting in Bryan, Texas, was raided by Kerr County Sheriff's Department, the weaponized Federal Bureau of Investigation tyrants, the U.S. Marshal tyrants, Bryan Police tyrants, and Texas State Police tyrants, because Susie Kamak, a member of the House of Representatives, had convened a common law court over the theft of her home, and they were calling it a simulated legal process, and they seized the demandant's laptop computer and carrying case, and the demandant has not received any of it back to this day. Susie and the Republic of Texas common law court judge both spent time in Texas jails over that matter, evidencing the state of Texas actors taking reprisals. Let's change that. Evidencing the state of Texas tyrants taking reprisals for political beliefs, more war crimes, and their pattern of war crimes against the people of the Republic of Texas. On 21 July 2014, the demandant's airframe power plant license and student pilot certificate were suspended because of the TSA's initial determination that you pose or are suspected of posing a risk of air piracy or terrorism or a threat to airline passenger safety. A true copy of the tyrant's letter is attached here too on Exhibit 5, all of which is incorporated herein by reference in its entirety. More war crimes by the Obama administration, taking reprisals for political beliefs with the Texas DPS malicious, slanderous, defamatory intelligence bulletin full of hearsay information obtained with an illegal search and seizure in violation of Article 4 Amendment and conspiracy with the Montana Highway Patrol. And because of the Five Eyes foreign enemy tyrant buddies in Communist Canada were sharing their smuggling conviction with their tyrant communist buddies here in retaliation because the demandant had the audacity to exercise constitutional rights of exhausting administrative remedies, seeking a redress of grievance and self-determined Texas national status, and evidencing their intent to deprive the demandant of his right to pursue happiness by getting compensation for labor. In August of 2015, after 6 weeks working there, the demandant was laid off from GKN Aerospace in Montgomery, Alabama, and when laid off, they held a meeting and told the demandant it had nothing to do with the work performance because they were very happy with the work performance, but their corporate office had ordered it. The head office of GKN Aerospace is in the United Kingdom, one of the foreign enemies Five Eyes Alliance, sharing their smuggling conviction from Communist Canada. That is the last job that a man had working in the aerospace industry, evidencing they intend to engage in slander and defamation to make sure the demandant is denied the right to pursue happiness by getting compensation for labor in support of their war crimes agenda against the demandant and the people of the Republic of Texas, in support of the Texas DPS malicious conspiracy with the Montana Highway Patrol and the Obama communist agenda in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. In the year 2017, while visiting the demandant's daughter and grandchildren, the daughter asked the demandant to leave because her husband, a prison guard for the Immigration Service at the time, was nervous about losing his security clearance. A true copy of the letter she gave the demandant is attached here too as Exhibit 6. all of which is incorporated herein by reference in its entirety, and further evidence that these military police and their bar member handlers, let's modify this a little bit, tyrants, and their bar member and their tyrant bar member handlers intend to slander and defame the defendant to make sure he's denied access to his own children and grandchildren in support of the malicious Texas DPS slander and defamation against him and the people of the Republic of Texas, and in conspiracy with the Montana Highway Patrol tyrants in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The demandant's sons, Nelson and Wilson, are afraid to talk to him for fear of losing their security clearance. More slander and defamation by the malicious Texas DPS tyrants, in conspiracy with the malicious Montana Highway Patrol tyrants and their military police, in conspiracy and their military police tyrants in conspiracy with their bar member handlers, tyrant bar member handlers for exercising U.S. constitutionally protected rights to petition the government for redress of grievance, and the Montana Highway Patrol tyrants and exhaust administrative remedies and exercise his right to self-determination as a Texas national in retaliation. Hold it now. That's way too long.
There was a suggestion, Glenn, in the chat by Shara. Maybe she wants to share it now. Want to go ahead, Shara?
Go ahead.
I can read it.
Okay.
There we go. Maybe she put it somewhere else. It was something about holding, something about harmless. I just caught it when it was on my screen, and now I'm not seeing it.
Yeah, I'm busy reading this. Okay, paragraph 66. The resolution of Congress says that because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, says in the preamble, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And as affirmed by Harold M. Stevens, Chief Judge of the U.S. Court of Appeals for the District of Columbia Circuit, in his article in the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon such subjects, how can they intelligently participate in determination of pertinent national policies? Therefore, we the people are the government, which is why it's called a republic. Matter of fact, that is why it's called a republic. During the Obama administration, the communist tyrants and the weaponized Federal Bureau of Investigation made war on the Republic by using sovereign citizen as a buzzword for persecution and prosecution, and then circulate numerous articles, news releases stating that all sovereign citizens are terrorists, as found in an ABC News article entitled Sovereign Citizens, Terrorism Assessment, Warns of Rising Threat from Anti-Government Extremists, by James Thomas on 30th of November 2015, and in the news article on RT.com entitled Sovereign Citizens Seen as Top Terrorist Threat by U.S. Law Enforcement by Brian Blanco on 5th of August 2014, and numerous other articles by stating they intend to murder any sovereign citizen without a trial, without due process of law, by Obama's military police order followers. All of the wrongdoers named herein are operating in support of Obama tyranny and his communist buddies to overthrow the republic, which is treason. Obama's weaponized Federal Bureau of Investigation tyrants even published a sovereign citizen quick reference in cooperation with the Joint Terrorism Task Force, a true copy of which is attached here to as Exhibit 19, all of which is incorporated herein by reference in its entirety. Many good and honorable public servants, in an effort to exhaust administrative remedies and exercise the Article 1 and Amendment right to petition the government for redress of grievances, in the year 2007, over a period of about 10 years, the demand has sent out thousands of notice and demands, almost all of them by registered mail, and the first paragraph of all of them says, "I accept your oath of office," and in all fairness, most of the government officials the notice and demands were sent to were just honest, hardworking officials. A judge in Johnson County, Texas, returned a copy of his oath of office and surety bond, and a county sheriff in New York returned an insurance claim form. The demandant would never do anything to cause injury to such honorable public servants because we need such people to keep the peace. And as said in the notice and demands, the demandant understands his duty to come to their aid when called upon, and that's under posse comitatus, the power or force of a county, the entire population of a county above the age of 15, which a sheriff may summon to his assistance in certain cases as to aid him in keeping the peace and pursuing and arresting felons, and will be there for them any time or any place. On the other hand, the Pennsylvania Assistant Attorney General tyrant returned a letter saying that if the demandant drives in Pennsylvania without a driver's license, they would arrest the demandant, put the demandant in jail. And the demandant took her letter with a copy of the notice and demand, made a 2-page criminal complaint, sent it to the U.S. Attorney in Harrisburg, Pennsylvania, and 2 weeks later got a letter saying, "We've referred this matter to the FBI." And 6 months later, the Pennsylvania Attorney General's website showed they had an acting Attorney General, which means the previous Attorney General left office before his term was up. County of Montague thieves and the minor estate. In 2021, the demandant converted silver to land. The County of Montague tyrants, under the direction of Texas Comptroller, proceeded to enslave the demandant. Let's modify that. With their minor estate, tax notices, tax liens, and threat letters. The demandant served registered mail like Catherine notice and demand, demanding they produce a bona fide contract, and they never responded to it in any way. The County of Montague tyrants filed a malicious tax suit in the 97th District Court. The demandant filed 78 criminal complaints into the case and sent them to the weaponized Federal Bureau of Investigation and the weaponized United States Attorney, and the weaponized Department of Justice tyrants ignored them in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, and self-determined Texas national status. The demandant filed a petition for writ of mandamus for the Second Court of Appeals to order the lower court to prove standing and jurisdiction, and the tyrant clerk in the Second Court of Appeals refused to accept it because the demandant is a vexatious litigant, and they were sure to send their letters refusing the petition to the 97th District Court and the liars' attorneys to make sure to notify them that the demandant could be denied due process with impunity and get them into the conspiracy as accomplices in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determined Texas national status. The demandant brought the case to the Republic of Texas common law jury, which issued an affidavit of finding of facts. The bought and paid for clerk tyrant, masquerading as a judge in the 97th District Court, subjecting the demandant to their star chamber with their forced legal counsel, and maliciously assaulted the demandant with the minor estate to justify the theft of his land, and enslaved the demandant for their Vatican handlers, and they were in process of selling the land. On the day of the sale, the demandant set off their extortion with their Federal Reserve note commercial paper fake money that are only for use in the District of Columbia under the Gold Reserve Act of 1934. The defendant has never in his life breached the peace, but the weaponized Federal Bureau of Investigation, military police tyrants under the direction of Yarborough, refused to investigate the felonies, and the weaponized U.S. attorney tyrants under the direction of Simonton refused to prosecute the felonies that the county of Montague engaged in support of their weaponized Department of Just Us and their communist handlers to implement the first plank of the Communist Manifesto, the abolition of private property rights in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. The defendant filed a lawsuit in Fort Worth federal court, and the tyrants Hal R. Ray and Reed O'Connor maliciously issued the findings, conclusions, and recommendations of the United States magistrate judge, which fails to be the required findings of fact and conclusions of law, which means it has nothing to do with facts or law, evidencing they intend to be accomplices to assault the defendant with the minor estate in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, and self-determine Texas national status. The defendant filed 78 criminal complaints into the federal lawsuit, and they maliciously got unfiled, evidencing the case was prejudged in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. One of the wrongdoers in the lawsuit was tyrant Stephen McCraw, director of the Texas Department of Public Safety, because of that intelligence bulletin. The defendant filed document 104, notice of objection to the magistrate judge's findings, conclusions, and recommendations, and motion to reconsider. The defendant filed a notice of appeal on 3rd March 2025, and it is in the U.S. Court of Appeals, and it's actually I'll have to modify that. Let's just make that yellow. The defendant filed document 108, notice of constitutional challenge, filed March 10th, because they're obviously assaulting the defendant with the minor estate. The defendant filed document 112, mandatory judicial notice of 12 presumptions, filed 30th of May, 2025, to defeat the presumptions that they like to take about trust for their Vatican handlers. In every document filed into the case, the defendant put himself down as a living man on the land of Texas, but because they're obviously using trust law, the defendant filed document 113, affidavit of life, filed 30th of May, 2025, to defeat the presumptions that the defendant is lost at sea, presumption of death that the tyrants maliciously take for their Vatican handlers, so they can assault people with their trust law and their Roman law, because a trust is property and has no rights, because the defendant has lots of first-hand knowledge of how they love to use trust law to enslave people for personal profit for their Vatican handlers in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. The defendant filed document 114, notice of void judgment, 30th of May, 2025. The tyrants Marshall Thomas and Leah Simonton maliciously have a problem with some of the things the defendant said in the federal lawsuit, as evidenced by complaint number 188-3286 filed with the Tarrant County District Attorney, and it's not even signed by Simonton or Thomas almost a year after the alleged incident, a true copy of which is attached here to it, Exhibit 7, all of which is incorporated herein by reference in its entirety. The court said nothing about it, and the defendant was trying to get a redress of grievances, which is a right under Article 1 and Amendment, because the thieves engaged in the theft of the defendant's land. And the case is not over because it's in the U.S. Court of Appeals for the Fifth Circuit as case number, and is now in the Supreme Court. The defendant also filed a petition for writ of certiorari with the U.S. Supreme Court challenging the constitutionality of the 1871 Municipal Corporation, the minor estate, the National Bar Foundation, because Article 1 of the Amendment requires Congress shall make no law respecting an establishment of religion, and it's all coming from the Pope. The defendant finds it interesting that the tyrants Thomas and Simonton filed this malicious criminal complaint. At the same time, the tyrant, Captain Michael Lugo, was maliciously complaining about the Republic of Texas common law court judgment, like they're piling on, trying to get in on the action in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. Furthermore, Thomas and Simonton are maliciously trying to interfere with the right to appeal this matter, which is another war crime, and Simonton is a former U.S. attorney and deemed to know the law. Therefore, it's deliberate, calculated, and malicious, and she is knowing intentional participation in all of these crimes described herein and cannot claim any plausible deniability or good faith. New Mexico arrest in conspiracy with the Texas DPS. On the 4th of August, 2025, about 9 p.m., the defendant was arrested by about 5 cars from the New Mexico State Police in the parking lot of the Crown Plaza Hotel in Albuquerque, New Mexico, after returning with a friend from dinner. The defendant was at an extraordinary science conference, and has gone to in early August for the last 7 or 8 years. The defendant asked to see the warrant, and they failed to produce it. While the defendant was in the back of the police cruiser, he heard the officer say, "Tell so-and-so I need that warrant." And the fax header shows that the warrants were faxed around 10:38 p.m., and the fugitive complaint shows the arrest took place at 9:16 p.m., more than an hour before the warrants were faxed, which is proof they failed to have the warrants when they arrested the defendant, and they failed to care if the warrants were lawful warrants, evidencing their flagrant disregard for the law or the Constitution. This is evidence that the malicious, weaponized Federal Bureau of Investigation tyranny and the Texas Department of Public Safety military police tyrants maliciously intended that the defendant exercise his right to resist their unlawful arrest, because everybody has a right to resist an unlawful arrest. An illegal arrest is an assault and battery. The person so attempted to restrain to his liberty has the same right to use force in defending as he would in repelling any other assault and battery. Because they're required to produce the warrant when they make an arrest, or the defendant can resist their unlawful arrest with lethal force if necessary. Special deputy is required to show his warrant if requested to do so. It is doubtless the duty of an officer who executes a warrant of arrest to state the nature and cause of charging process which gives him the authority to professes to exercise, and if it is demanded to exhibit his warrant, that the party arrested may have no excuse for resistance. So the New Mexico State military police tyrants would have an excuse to murder the defendant if he exercised his right to resist their unlawful arrest with lethal force if necessary. So the military police tyrants could maliciously shed some innocent blood for their handlers, and they could all justify the existence of the Joint Terrorism Task Force and say the Joint Terrorism Task Force is doing their job to kill another sovereign citizen terrorist, and the defendant would be dead. And who's going to say otherwise? This is all evidence of the tyrant's illegal search and seizure of property in government hearsay database, that the defendant has an interest in conspiracy with Casey Brashear, because they knew where the defendant was because of the license plate on the car he was traveling in. The malicious Texas DPS military police tyrant actors. Let's shorten that a little bit. Have known for decades that the defendant was involved with the Republic of Texas, as evidenced by their intelligence bulletin, full of hearsay information that was obtained with an illegal search and seizure in violation of Article 4 Amendment. This is deliberate and calculated war crimes, taking reprisals against the defendant and the people of the Republic of Texas for political beliefs. With their malicious slander and defamation by the Texas DPS tyrants, the Tarrant County District Attorney tyrants, and conspiracy with the malicious Montana Highway Patrol tyrants, and now the malicious New Mexico State military police tyrants. The defendant learned later that on the 5th of August 2025, the tyrant Casey Brashear had maliciously and knowingly executed an expired search warrant that was issued on 1 August 2025 by Alan Whalen, magistrate, Grapevine Municipal Court, within 3 days, with 3 days to execute, thereby conducting an illegal search of the house the defendant has been living in, to break into the house, aggravated burglary, and pillage property of the defendant and his roommates, valued at over $200,000. and had maliciously arrested several people who were on a common law jury that had been conducted. A true copy of the warrants attached here to it is Exhibit 18, all of which is incorporated herein by reference in its entirety. They had barricaded off all the streets nearby, making as big a spectacle as possible for the neighbors to see what happens for their slander and defamation, with dozens of unknown officers who are busy hiding their identities. Coward officers who are busy hiding their identities to avoid consequences of their criminal activity under the direction of tyrants Casey Brashear and Bobby LaPena, Bedford Chief of Police, in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and self-determine Texas national status. The Bedford Chief of Police tyrants were also notified about the expired warrant, and the Bedford Police was there helping with the aggravated burglary, and the cowards failed to have name tags, and they turned over all public information requests to their attorneys, obstructing the ability to get names of those involved, and they even told the homeowner when confronted about the expired warrant, "Oh, we do this all the time," evidencing the flagrant disregard these military police have for their requirements under the Constitution. If there was any organized criminal activity, it's the military police tyrants and their criminal street gang with common identifying colors. Fake warrants in New Mexico. On the 5th of August 2025, they held an arraignment in Bernalillo County Jail and gave the demandant a copy of the fake warrant that failed to have a court seal as required by the Authentications Act, which was the very first act of Congress in the second session and is the supreme law of the land under Article 6, Clause 2. True copies of the fake warrants are attached hereto at Exhibit 8, all of which are incorporated herein by reference in their entirety. There were 3 felonies: organized criminal activity, terroristic threat, and terrorism, in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, and self-determine Texas national status, and conduct a common law court. The fugitives' complaints were signed by Patrick Chavez, New Mexico State Military Police tyrant, and the fax time on the top of the page of the warrant show they were faxed at 10:34 p.m. after the arrest took place at 9:16 p.m., as evidenced by the fugitive complaints, a true copy of which are attached hereto at Exhibit 9, all of each of which are incorporated herein by reference in their entirety, in which Chavez says the minor state, fiction of law, is a fugitive from TX, which is a military region in the District of Columbia that overlays the territory properly included within and rightfully belonging to the Republic of Texas, which was erected in a new state to be called the State of Texas, as evidenced by the Act of Congress at 9 Stat 1 and HGR 1, dated 29th of December, 1845, at 9 Stat 108, and has been under martial law since 1861, when Galveston, Texas was invaded by the U.S. Union Army, and at the time the demandant was arrested, the demandant was a senator of the Republic of Texas because they were deliberately calculated, maliciously taking reprisals for political beliefs, and they want the demandant dead in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, conduct a common law court, and self-determine Texas national status. The fake warrants are evidence that the tyrant Stephen Jones conspired with tyrants Casey Brashear and maybe I'll just modify that. Tyrant Casey Brashear and tyrant Captain Michael Lugo, and the New Mexico State Military Police tyrants. To threaten, coerce, intimidate, injure the demandant in the free exercise of the right to engage in constitutionally protected activities, violate the demandant's rights under color of law with their assault, false arrest, kidnapping, false imprisonment, and retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievance, exhaust administrative remedies, conduct a common law court, and self-determine Texas national status. A true copy of Captain Lugo's criminal complaints attached hereto as evidence in Exhibit 10, all of which is incorporated herein by reference in its entirety. The fake warrants were also bills of pains and penalties, similar to a bill of attainder and unconstitutional, as discussed in the section about the law below. Therefore, Stephen Jones was maliciously purporting to be a judge in a court and was impersonating a public servant, and was part of a malicious conspiracy against the demandant to threaten, coerce, injure, intimidate the demandant in the free exercise of his rights to get redress of grievance, exhaust administrative remedies, hold a common law court, and self-determine Texas national status. Tyrant Stephen Jones also maliciously signed Kenneth Ouimet's fake warrants, and they also failed to be authentic because there's no court seal as required by the Authentications Act at 1 Stat 122, which was the very first act of Congress in the second session and is the supreme law of the land. There are also bills of pains and penalties for the same reasons. The malicious fake warrants are bills of pains and penalties in the demandant's case. Therefore, Stephen Jones was impersonating a public servant in violation of his Texas Penal Code 37.11 when he issued the malicious fake warrants for Kenneth Ouimet, and is also part of a conspiracy to threaten, coerce, injure, intimidate Kenneth Ouimet in the free exercise of constitutionally protected activity of holding a common law court, self-determined Texas national status, and Ouimet had the right to resist that arrest with lethal force if necessary. True copies of the fake warrants used to falsely arrest, kidnap, and falsely imprison Kenneth Ouimet are attached hereto as Exhibit 11, all of which are incorporated herein by reference in their entirety. The fact there's no court seal is required by the Authentications Act of 1 Stat 122, which is the supreme law of the land under Article 6, Clause 2, fails to be a curable defect because the arrest has already taken place, and in the demandant's case, the tyrants failed to even care what the warrant looked like, which means it's deliberate, calculated, malicious assault, kidnapping, and false imprisonment by the tyrants Stephen Jones, Phil Sorrells, Casey Brashear, Andrea Brandt, Captain Michael Lugo, Leah Simonton, Marshall Thomas, and all the officers of the New Mexico State Military Police in a conspiracy and in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and conduct a common law court and self-determine Texas national status. The demandant waived extradition without prejudice, which means there is no contract, has waived no rights, and gave no evidence against himself. And the U.S. Marshal brought the demandant to Tarrant County Jail in Fort Worth, true copies of which are attached hereto as Exhibit 12, all of which are incorporated herein by reference in their entirety. Because the demandant signed the extradition waivers without prejudice, they failed to be authorized to pay for the malicious arrest, assault, kidnapping, false imprisonment, and extradition from the minor estate treasury direct account, and the tyrant Phil Sorrells paid for it from the Tarrant County public funds, which means it's also misappropriation of public funds, because we flew to Houston, and then the U.S. Marshal rented a vehicle, and the U.S. Marshal told the demandant he made his living doing extraditions. The demandant told the U.S. Marshal he'd had no trouble from the demandant because the charges were completely spurious, and the demandant did not want to add real charges to the fake charges. And then when dropping off the demandant, the U.S. Marshal thanked the demandant for his cooperation during the trip. On 11th of August 2025, the demandant was arraigned in Fort Worth, given a punitive bond of $500,000 with egregious punitive bond restrictions like GPS ankle monitor, no internet, and home confinement, which is signed without prejudice, which means there is no contract, waived no rights, admitted no evidence. A true copy of the magistrate warning is attached hereto at Exhibit 13, all of which is incorporated herein by reference in its entirety. Furthermore, because the demandant signed everything without prejudice, and the guards were asking some of the other prisoners, why is he putting without prejudice here? Because that's done literally every time the demandant was given something to sign, including the malicious forced medical experiments. Therefore, they failed to be authorized to pay for the false imprisonment from the minor estate treasury direct account, and the tyrant Phil Sorrells paid for it from Tarrant County public funds, which means it's also a misappropriation of public funds because the demandant is sure that the Tarrant County Jail is a for-profit business. The Greek derivative of the word sorcery is pharmakeos, and the Tarrant County Jail has a whole floor dedicated to tyrant Satanists peddling their pharmaceuticals. And with their forced medical experiments, the first thing they did was take blood pressure, and then it was continuous harassment to take blood pressure because they said the demandant had high blood pressure, even threatening segregation, solitary confinement, and forced medical experiments for the high blood pressure because the demandant might have a stroke. The demandant told them that he read an article about how stroke symptoms are very similar to symptoms of a vitamin C deficiency, which is scurvy, but hospitals and medical doctors make no money from selling vitamins, and they had none because the demandant asked for vitamin C. And the jail food is completely devoid of vitamins. The demandant had to beg other prisoners for their orange peels because sometimes they would work as trustees in parts of the jail where the reward was an old dried-up orange, but orange peels are almost pure vitamin C. And the demandant would beg for the orange peels so we could eat them and get a little bit of vitamin C because it certainly was not in the food. And the tyrant sorcerers would love the demandant to start exhibiting symptoms they could claim are stroke symptoms so the demandants could peddle their pharmaceuticals. On the day before the demandant was released, he filed a grievance for their forced medical experiments and wants it listed here as a war crime. It got to the point they would wake up the demandant to get blood pressure taken, and then when refused, they would make the demandant sign for it, and the demandant would insert without prejudice. And then they'd have to get into an argument about the signature and had to explain to the tyrants that Title I, Section 1 of U.S. Code says the signature is a mark and can be anything, even the smallest little dot or a smiley face. And for this, it's without prejudice. Around 21st of August, a court-appointed lawyer, Valerie Vale, came to see the demandant in Tarrant County Jail and offered to plea bargain the matter. The demandant accepted her offer. The demandant sent Valerie Vale 2 letters from the Tarrant County Jail, the first on or about the 25th of August, 2025, an affidavit of fact saying that we're doing a common law court with the demandant was previously charged d'affaires with the Republic of Texas, which is equivalent to an ambassador, and had lifetime diplomatic immunity, protection under international law, and also had immunity from public statements under the Articles of Confederation, and a motion for an identity hearing to establish that the demandant was not lost at sea, is not their minor estate, and is a man on the land of Texas to remove the demandant from trust law, which is part of the Pope's Roman canon law. And the second letter on or about 2nd of September 2025 explained that the demandant is going to have a friend get the lawyer a certified copy of Document 113, Affidavit of Life, and Document 112, Mandatory Judicial Notice of 12 Presumptions from Federal Court Case 424 CV 0881 for the lawyer to introduce as exculpatory evidence into the evidence file, and a motion to quash the warrants because they failed to be authentic warrants, which would make the arrest unlawful and illegal, and everything that precipitates from an unlawful illegal arrest is also unlawful and illegal, precipitating dismissal of the case. A true copy of the affidavit of fact as Exhibit 14, the motion for an identity hearing as Exhibit 15, and the motion to quash the warrants as Exhibit 16, all of which are incorporated herein by reference in its entirety. On 17 September 2025, Valerie Vale came to see the demandant in Tarrant County Jail and told him all charges were dismissed, evidencing it was a malicious prosecution. Because when the legitimacy of arrest is disputed, it is presumed to be unlawful, and the burden of proof shifts onto the officers making the arrest. The demandant was released on 18 September 2025, a total of 45 days after being maliciously assaulted, unlawfully arrested, kidnapped, falsely imprisoned by tyrants in New Mexico, and conspiracy with tyrants Phil Sorrells, Casey Brashear, Leah Simonton, Andrea Brandt, Stephen Jooms, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, and Patrick Chavez, and his New Mexico State Police tyrant buddies. In retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and conduct a common law court and self-determine Texas national status. The demandant picked up his car in Albuquerque, New Mexico on 22 September 2025, and it cost $1,064.62 from the storage company, as well as over $500 for a rental car for a week. and $500 for Darren Swain to travel to Albuquerque and bring the car back. The demandant later learned that the tyrant Chris Johnson, judge of Hays County Court at Law 2, maliciously issued a fake warrant that failed to have a court seal to search the car in Hays County on 1 August 2025, true copy of which is attached here to it, Exhibit 17, all of which is incorporated herein by reference in its entirety. Therefore, Johnson was purporting to be a judge, and the court evidence he was impersonating a public servant. Also, tyrants Phil Sorrells, Casey Bashir, Leah Simonton, Andrea Brandt, Stephen Jooms, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, and Patrick Chavez and his New Mexico State Police buddies are maliciously subjecting the demandant and the people of the Republic of Texas to their satanic religious ceremony, assaulting us with their minor estate, which is necromancy, fraud, deception, and idolatry, which is another war crime in retaliation for exercising U.S. constitutional rights to seek a redress of grievances, exhaust administrative remedies, conduct a common law court, and self-determine Texas national status. The demandant found out that all the malicious charges against the common law courts were dismissed as well, evidencing that the whole thing was a malicious prosecution by tyrants Phil Sorrells, Casey Bashir, Leah Simonton, Andrea Brandt, Stephen Jooms, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, in support of their slander and defamation to terrorize we the people of the Republic of Texas into refraining from constitutionally protected activity to justify their work as the Joint Terrorism Task Force to make work for themselves by creating terrorists so they could shed some innocent blood for their handlers. Further evidence they're actually the terrorists, conspiring to threaten, coerce, injure, intimidate everyone on that common law court in the free exercise of our right to engage in constitutionally protected activity of holding a common law court under color of law, as well as violating the demandant's right and the rights of everyone on that jury under color of law, as well as assault, kidnapping, false imprisonment for every fake warrant executed in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, conduct a common law court, and self-determine Texas national status. On 20th of September 2025, the demandant's wife called from Vancouver and wanted to know what happened because it was on Facebook that the demandant was in jail, and the demandant explained to her what had happened, evidencing the malicious defamation, slander, terrorism, and war crimes by the Texas DPS tyrants and the Montana Highway Patrol military police tyrants and the Joint Terrorism Task Force tyrants and their military police tyrants and their bar member handler tyrants named herein and others known and unknown in retaliation for the demandants exercising constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, self-determine Texas national status, and conduct a common law court. The demandant asked his daughter in Arizona what they were doing for Christmas on 7th of October, and she answered the text when she said she was not comfortable having the demandant in her home, but could meet for dinner somewhere. Further evidence of the malicious slander, defamation, terrorism, and war crimes being engaged in by the military police tyrants and their bar member handler tyrants and the weaponized Federal Bureau of Investigation tyrants and the Joint Terrorism Task Force tyrants and the Texas Department of Public Safety tyrants and the Montana Highway Patrol military police tyrants. Let's shorten that a little bit. Montana Highway Patrol tyrants should be good. In retaliation for the demandant exercising constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, self-determine Texas national status, and conduct a common law court. The tyrants Phil Sorrells, Casey Bashir, Leah Simonton, Andrea Brandt, Stephen Jooms, R. Joseph Rothrock, Marshall Thomas, Captain Michael Lugo, and Patrick Chavez and his New Mexico State Police tyrant buddies, and his malicious weaponized Federal Bureau of Investigation, Joint Terrorism Task Force tyrants, and the state of Texas tyrants, the Texas Department of Safety tyrants, the Texas State Police tyrants, the Tarrant County District Attorney tyrants, and the Hays County District Attorney tyrants, and a malicious conspiracy with the Montana Highway Patrol tyrants have repeatedly engaged in war crimes against the demandant and the people of the Republic of Texas using the minor estate, Canon Law and Commerce Clause, Article 1, Section 8, Clause 3, to bring the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. By imposing the District of Columbia plenary power dictatorship tyranny and taking reprisals for political beliefs, taking reprisals for religious beliefs, subjecting the people of the Republic of Texas to their satanic religious ceremony with their fraud, deception, idolatry, necromancy for their handlers under the Roman canon law, failing to provide a fair and regular trial by jury as required by the supreme law of the land, but instead subjecting us to their inquisitions for their Vatican handler tyrants, and selling us into slavery, denying us the right to pursue happiness, coercing information from us and from third-party government hearsay databases with no authority, coercing plea bargains, illegal search and seizures, denials of due process of law, torture, cruel and unusual punishment, forced medical experiments, punishing the men and women of the Republic of Texas for the crimes of the minor estate, taking the peaceful men and women of the Republic of Texas hostage for the minor estate, pillaging our land and other property, fake warrants, unlawful arrests, kidnappings, false imprisonment, and attempted murder, because they have a duty to produce a lawful warrant when making an arrest, and we have a right to resist an unlawful arrest with lethal force if necessary, and other war crimes too numerous to count, and the weaponized Federal Bureau of Investigation refused to investigate these crimes, and the weaponized U.S. attorneys refused to prosecute them because we do not recognize you, speaking of the Republic of Texas, in support of their targeted justice.com agenda, and because federal employees are busy supporting the war crimes and participating in the war crimes and claiming a good faith excuse. And this is Article 4, General Orders 100, Libra Code. All wanton violence committed against persons in the invaded company and destruction of property not commanded by the authorized officer, all robbery, all pillage, all sacking, even after taking place by main force, all rape, wounding, maiming, or killing such inhabitants are prohibited under penalty of death or other such severe punishment as may seem adequate for the gravity of the offense. A soldier, officer, private, in the act of committing such violence and disobeying a superior order ordering him to abstain from it may be lawfully killed on the spot. That means they get to get away with it once. And this is Texas Code of Criminal Procedure, Article 38.23. No evidence obtained by an officer or other person in violation of any provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States of America shall be admitted in evidence against the accused on any trial of any criminal case. It's an exception to the provisions of subsection A that this article of evidence was obtained by a law enforcement officer acting in objective good faith reliance upon a warrant issued by a neutral magistrate based on probable cause. Good faith. As long as they can claim good faith, they get away with it. A good faith reliant, a court order, a grand jury subpoena, legislative authorization, statutory authorization, including a request of a governmental entity under this title, a request of an investigative or a law enforcement officer under Section 2518.7 of this title, a good faith determination, that's Section 2511.3 of this title, permitted the conduct complained of, is a complete defense to any civil or criminal action brought under this chapter or any other law, evidencing their malicious intent to perjure their oaths to the supreme law of the land in order to be the second national government that's talked about in the dissenting opinion, Downs versus Bidwell, that is maintained by Congress outside and independently of that instrument. In retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, conduct a common law court, and self-determine Texas national status. The rights protected by the Geneva Convention relative to the protection of civilians in a time of war of 1949 cannot be renounced, waived, or given up. Okay, so all these war crimes I talked about, can't give them up. The weaponized Federal Bureau of Investigation, Agent Casey Brashear, tyrant, brags how he maliciously got Bonnie straight, previously Bonnie Thomas into Texas jail and has bragged that he intends to shut down the Republic of Texas. And Bonnie Strait was chief counsel for the Republic of Texas for 4 years, from 2018 to 2022, and is entitled to lifetime diplomatic immunity under international law as an executive officer for the Republic of Texas. And tyrant William C. Bosworth, judge of the 413th District Court in Johnson County, Texas, is currently doing to Bonnie what the communists always do to their political dissidents: put them into mental institutions to perform forced medical experiments on her by foreign immigrant tyrant Dr. whatever his name is, who threatened to maliciously subject Bonnie to a forced medical experiment with the pharmaceutical called Abilify. For more war crimes against the people of the Republic of Texas by Dr. Valama, Casey Brashear, Andrea Brandt, Marshall Thomas, Captain M. Lugo, Phil Soros, Bobby LaPena, and the Texas military courts tyrants operating under the Pope's Roman law of trusts, as described herein. Furthermore, under Title I, U.S. Code Section 1, it says someone who is incompetent is insane. Right? Right here. The words insane and insane person shall include every idiot, insane person, and person non compos mentis. That means incompetent. Which means that just because Bonnie Strait might not be 100% correct in her arguments, incompetent in some small area, because the tyrant Pope's fake judge Bosworth in the case wants to sit there and play stupid and presume Bonnie Strait is dead or lost at sea and impose tyrant Pope's trust law on Bonnie Strait, she's maliciously declared insane and committed to a mental institution for forced medical experiment war crimes. The War of Independence was fought over the imposition of martial laws found in the Cause of Necessities for Taking Up Arms, issued by the Continental Congress in 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof the published and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charge. That sounds like Roman law. We saw the misery to which such despotism's dictatorship, folks, would reduce us. To supersede the course of common law, instead thereof the published and order the use and exercise of the law martial, as evidenced by the organic law of the Declaration of Independence, which is a list of grievances against King George. He's combined with others, the Pope, to subject us to a jurisdiction foreign to our Constitution, that's Roman law, unacknowledged by our laws, giving his assent to their acts of pretended legislation. When they talk about pretended legislation, they're talking about the Pope. For transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury. He's abdicated government here by declaring us out of his protection and waging war against us. And King George even signed the definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, all of which evidences the true enemy being the tyrant Vatican. The tyrant Pope now owns and operates the 1871 Municipal Corporation, 12 Stat 419, with the bankruptcy emergency. It's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, declared by President Roosevelt, being bankrupt and insolvent. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. That's congressional record, and on the same date, this is U.S. Senate Report number 93-549, 1973. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens, The majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have been, in varying degrees, been abridged by laws brought into force by states of national emergency. Because martial law is the law of emergency and necessity. There's three kinds of martial law. This is ex parte Milligan. Full martial law is when accidentally invaded by a foreign enemy or insurrection, troops are put on the street. Martial law proper is the law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martial. And martial law rule, the law of emergency or necessity used during peacetimes, which makes it satanic. And the Satanists are using the tyrant pope's Roman law of capitis diminutio, loss of status, highest and most comprehensive, through the use of capitalization. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. I'll be right back. I got to step aside for a minute. Okay, moving right along. To populate the prisons. Sorry?
I said, okay, good.
To populate the prisons by selling people like Ken Ouimet, the Demanet, and Bonnie Strait into slavery, because the administrative proceedings under the tyrant Pope's Roman canon law of trust, there are more people in prison in America as a percentage of the population than there are in communist China, or were in the Soviet Union, or the worst dictatorship in history. If there were Christians here, the Pope's tyrant bar members doing it would get their necks stretched. And the Innocence Project estimates that 60% of prisoners are innocent. But it's such good business for the tyrant Vatican and the Roman law so-called courts, which is one of the grievances in the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our town, and destroyed the lives of our people. All of which was planned and orchestrated by the tyrant Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take the place. When the United States rules the world, the Catholic Church will rule the world, and that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, March 5th, 1903. And the tyrant Pope now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaia military staff. That's right here. You can see my mouse. That's carried in battle by all Roman commands and planted on all conquered nations, is sitting on the right side of the Speaker's podium in the U.S. House of Representatives. And the two Roman fascia, bundle of rods bound into weapons symbolizing under the rule of a single man. They're on the wall on each side of the Speaker's podium in the U.S. House of Representatives. And there's an image, and that's the Roman Achaia military staff, and there's the fascists. Which is also why tyrant Nancy Pelosi, when she was Speaker of the U.S. House of Representatives, told the members of the House, we can't read this bill until after we pass it, because she was taking instructions from her tyrant Vatican handlers, all of which is evidencing the fact that the 1871 corporation currently operating in the District of Columbia is a Vatican-dependent city-state. And the Vatican's tyrant Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican City State in criminal matters that talks about concurrent jurisdiction in other papal states, like the District of Columbia and the City of London, Crown of England. When this is it right here. When the same matters are prosecuted in other states, the provisions in force in Vatican City State on concurrent jurisdiction shall apply. And that's apostolic letter issued motu proprio, entering into force 1 September 2013, which means the tyrant Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3. And the Vatican's tyrant Pope Francis came and addressed his own and operated Congress on 24 September 2015, and the tyrant Pope's owned and operated Federal Bureau of Investigation, Joint Terrorism Task Force tyrants are assaulting the demandant and the people of the Republic of Texas with their Roman fiction of law, minor state, Sestike usufruct, with the Pope's Sestike V Act of 1666, which was brought into the United States with the Code of Law for the District of Columbia, 1901, an act to establish a code of law for the District of Columbia, the legal estate to be the Sestike use, now codified at 31363.6, and the Pope's necromancy, Sestike use, and people are presumed dead at Chapter 3, absence of 7 years, presumption of death. He shall be presumed to be dead in any case wherein his death shall come into question. And the tyrant Pope's Uniform Commercial Code, but individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges, where they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. Whenever the Uniform Commercial Code creates a presumption with respect to a fact, or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until the evidence is introduced that supports a finding of its non-existence. All of which is unconstitutional because Article 1 an amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In 2024, we in the Republic of Texas wanted to peacefully help Republic of Texas people currently in Texas jails. We held a common law court. We got a known case that was upheld by the 14th District Court in Dallas. Case 95-07735 on 19 September 1995, called Abello Corporation, WFAA-TV versus Johnny Johnson and Lakeview Developers, to use it as a template. We organized a common law court, got seals, followed it in every detail for about 6 cases, one of them for Ken Ouimet that was filed into his case, one of them for the demandant that was filed into his case, to get some constructive feedback on whether we need to make corrections. Because 30 years had passed, our sole interest was to help people, especially people who are associated with the Republic of Texas. We needed to be recognized by the state of Texas military government to help people in Texas jails. We, the people of the Republic of Texas, wanted nothing but a peaceful, friendly relationship with the military government of the state of Texas. On 30th of June 2025, the demandant served R. Joseph Rothrock, Special Agent in Charge of the Federal Bureau of Investigation, Dallas Field Office, by registered mail, a notice and demand, and the first paragraph says, I accept your oath of office. But the demandant should know better than to think that the tyrant Rothrock, the Special Agent in Charge of the Dallas Weaponized Federal Bureau of Investigation, would honor their oath of office. It appears that the tyrant Casey Brashear and his military police tyrants are going to get their desire to eliminate the Republic of Texas because the demandant has resigned his Senate seat, and all the rest of them are running scared, terrorized, because of the tyrant Brashear's malicious prosecutions. So tyrant Brashear can be proud that he's such a good terrorist and have perjured their oaths to support the supreme law of the land, violated the supreme law of the land in support of their District of Columbia military dictatorship. The people of the Republic of Texas are refraining from engaging in constitutionally protected activities after being terrorized by tyrant Brashear and his military police tyrants and their bar member handler tyrants. Tyrant Casey Brashear and his weaponized Federal Bureau of Investigation military police tyrant buddies, Andrea Brandt, Captain M. Lugo, and the Joint Terrorism Task Force, are the terrorists. terrorizing the people of the Republic of Texas with their malicious prosecutions, in a malicious conspiracy with the Texas DPS tyrants, the Montana Highway Patrol military police tyrants, and then when we turn up dead, they get to pillage the fake money from the Treasury Direct account under GlennWinningham Fern in the defendant's case under the Hague Convention concerning the International Administration of the Estates of Deceased Persons, concluded 2nd of October 1973, and the defendant's not suicidal, but if the defendant does turn up dead, this is deathbed testimony, or the defendant will be subjected to their District of Columbia military prisons with false arrest, kidnapping, false imprisonment, just like what has already happened as described herein with their warrants that fail to be authentic and their Roman canon law so-called courts. Therefore, whether they enslave the defendant or kill him resisting their slavery, either way, it's a win-win-win scenario for these military police tyrants and their bar member handler tyrants. Violating our rights to engage in constitutionally protected activity under color of law and in conspiracy to threaten, coerce, injure, intimidate us in the free exercise of our rights to engage in constitutionally protected activity under color of law. And so then this is a section on the law. Texas DPS tyrants, illegal searches and seizures. All the information in the Texas DPS Intelligence Bulletin, as well as the fugitive complaints and warrants in the government computer database, is hearsay, including the hearsay evidence of the minor estate's name, date of birth, social security number, social security account number, with the Treasury and other hearsay evidence, license plates, etc., that is evidence of the tyrant's illegal search and seizure of property in government hearsay database. The defendant neither admits nor denies the validity of any of the information. All the information is inadmissible because it is hearsay, and the defendant failed to admit any of it, and all of it was obtained with an illegal search and seizure of property in which the defendant has an interest in government hearsay databases in violation of Article 4 Amendment. All databases, government or otherwise, are full of hearsay information, and the defendant requires the opportunity to cross-examine the source of the hearsay information to determine the veracity of that information, but it was unlawfully obtained. Nobody has produced any lawful search warrant signed by a judge with the court seal acting in his official capacity, authorizing the search of government hearsay databases, describing what exactly they're allowed to search for as required by Article 4 Amendment, and the Authentications Act, 1 Stat 122, which is the supreme law of the land under Article 6, Clause 2. Therefore, this court is required to presume that no such search warrants exist. Therefore, it should be suppressed. There is no evidence introduced by tyrants Lugo or Brashear or the Texas DPS or anyone else at any time in any case that the defendants involved in any contracts involving their minor estate. Therefore, the court is required to presume that no such contracts exist, and the presumption that the defendant is dead to facilitate their use of trust law, which is part of the tyrant Pope's Roman canon law, cannot be used to escape from constitutional restrictions of their oath of office to the supreme law of the land. And this is the power to create presumptions is a model means of escape from constitutional restrictions. That's U.S. Supreme Court, Bailey versus Alabama. And this is Article 6, especially since the defendant is posterity as found in the preamble. The defendant was maliciously arrested in a parking lot at the Crown Plaza Hotel on the east side of the Rio Grande River, which means the defendant was on the territory properly included within and rightfully belonging to the Republic of Texas. I was on the east side of the Rio Grande River. That's Texas. As evidenced by the Act of Congress at 9 Stat 1 and HJR 1, dated 29 December 1845. At 9 Stat 108, when arrested and was at the time a senator of the Republic of Texas, and the New Mexico State Police tyrants unlawfully and maliciously arrested the defendant, falsely imprisoned the defendant, kidnapped the defendant, maliciously in a malicious conspiracy with the Texas military police tyrants and their bar member handlers for engaging in constitutionally protected activities of a common law court seeking redress of grievance, self-determining Texas national status, and exhausting administrative remedies. Under the Articles of Confederation, Article 4, Clause 4, because the defendant was at the time a senator of the Republic of Texas, the defendant was entitled to immunity from public statements, and the defendant is entitled to immunity from arrest or imprisonment because there were no common law crimes by the defendant, as evidenced by the fact that all the charges were dismissed. And there were members of the Republic of Texas executive branch at the Extraordinary Science Conference that the defendant was attending, and the Crown Plaza Hotel in Albuquerque, and the New Mexico State Police caused a breach of the peace with their unlawful arrest, kidnapping, false imprisonment, and conspiracy with the Texas military police with their bar member handlers in retaliation for exercising U.S. constitutionally protected rights to seek redress agreements, exhaust administrative remedies, conduct a common law court, and self-determine Texas national status. The fake warrants were also bills of pains and penalties, similar to a bill of attainder, and unconstitutional because it named the minor estate and its date of birth, which is a fiction of law. A court of general jurisdiction is presumed to be acting within its jurisdiction until the contrary is shown. Okay, so it was issued by the 45th District Court, as evidenced by the judge who signed it maliciously not acting in his official capacity. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made and exercise of such power is treated as a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. It is familiar law that when special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, that means for the purpose of this proceeding only, a court of inferior or limited jurisdiction. Because it was maliciously legislating from the bench under Roman law. Fictions of law, this is Bouvier's Law Dictionary. Fictions of law were invented by the Roman praetors, who not possessing the power to abrogate the law were nevertheless willing to derogate from it under the pretense of doing equity. Fiction is the resource of weakness, which in order to obtain objective assumes as a fact what is known to be contrary to truth. When the legislator desires to accomplish his object, he need not feign, he commands. Fictions of law owe their origin to the legislative usurpations of the bench. So when the judge is on the bench and he's dealing with a fiction of law, he's commanding. Okay, he becomes a legislator, and that makes it a bill of attainder, bill of pains and penalties, because a bill of pains and penalties, similar to a bill of attainder, is a legislative act that applies to named individuals that inflict punishment without a judicial trial. And this is U.S. versus Lovett, Supreme Court. Bill of attainder means legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. And a bill of attainder prescribes punishment without a judicial trial. That's Black's 8. A bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So bill of attainder is the death sentence, and anything else is bill of pains and penalties. Because judges only hold office during good behavior, and engaging in malicious legislative acts from the bench is bad behavior and derogation of common law. That's Article 3, Section 1. All Article 3 judges are required to be neutral and unbiased. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Only an Article 3 judge can make decisions of life, liberty, and property. And this is Thomas. Says cases involving deprivation of transfers of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts. Where a controversy of such character is to require exercise of judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest the judicial power in any other judicial tribunal, or of course in any executive officer, administrative, or executive board, since they're incapable of receiving it. And then there's a whole bunch of court cases that talk about the same thing. When the legitimacy of the arrest is disputed, is presumed to be unlawful, and the burden of proof shifts on the officers making the arrest. The only thing the plaintiff needs to do is to allege a false arrest, is either that the defendant made an arrest or imprisonment, or that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff has shown he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumed it to be unlawful. Burdens on the defendant, the cop, to show the arrest was by the authority of the law. Any arrest made without a proper warrant, signed by a judge, backed up by an affidavit from two persons that states under penalty of perjury you've been broken a contract or hurt somebody, if challenged by the defendant, is presumptively invalid. As in the case of illegal arrest, the officer must keep within the law at his peril. When they dismissed all of the charges because of the false arrest as evidence it was a malicious prosecution. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. When they dismiss the charges, they're saying there's no probable cause. That means it was malicious. And that's what this Thompson versus Clark is talking about in 2022, U.S. Supreme Court. That's a recent U.S. Supreme Court case. All of this is evidence that there's no justice in Texas military court tyranny because of the bought and paid for clerks masquerading as judges like tyrant Stephen Jones, Elizabeth Beach, Hal R. Ray, Reed O'Connor, William C. Bosworth, Chris Johnson, and Patricia Coleman Byers want to sit there and play stupid and assault people standing in front of them and pretend they're the minor estate Sestake usufruct created with the tyrant's post-Sestake V Act of 1666 and brought into the United States with the Code of Law for the District of Columbia in 1901, an act to establish the Code of Law for the District of Columbia, the legal estate to be the Sestake use, and the tyrant Pope's necromancy, Sestake use. People are presumed dead, and that's presumption of death, so they can assault you with the minor estate and trust law, which is part of the tyrant Pope's Roman canon law, to engage in a commercial transaction under the tyrant Pope's Uniform Commercial Code. And this is that Braswell case that we read earlier. Individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. So they're assuming when they ask you, they talk to you, they're assuming that you're representing that minor estate. That's what they're doing, and you got to defeat that. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides a fact is presumed, the trier of fact must find the existence of fact unless and until evidence is introduced that supports a finding of its non-existence. That's UCC 1-206. To justify pillaging the fake money from the Treasury Direct account because they get fees for personal profit or gain under the Code of Law for the District of Columbia, now called United States Code, drawing a complaint at 31 Stat 1666, issuing a commitment. That's what they issue when they send you to jail, okay? That's called an order of commitment, and they get a piece of the action. Drawing a bond. They get a piece of the action when they do the bond, okay? You think that fucking bonding company's doing the bond? Bullshit. It's coming from that fucking judge, and he's getting a piece of the action, which is unconstitutional because Article 1 of the amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Randy Kelton routinely will take criminal complaint to a tyrant judge who is required to issue a warrant, and all of them have routinely refused to do anything, and this has happened dozens of times. Violations of specific articles of the Geneva Convention relative to the protection of civilians in the time of war of 1949 include but are not limited to Articles 27, 31, 32, 33, 34, 52, 53, 54, and 71. The weaponized Federal Bureau of Investigation tyrants and the weaponized Department of Justice, just us tyrants, completely ignored dozens of criminal complaints filed into the County of Montague case, but Captain Michael Lugo files a criminal complaint with absolutely baseless charges, and the Joint Terrorism Task Force terrorists arrest more than half a dozen people with fake warrants from their corrupt military court tyranny for their military dictatorship, hoping to shed some innocent blood for their tyrant handlers in retaliation for exercising U.S. constitutionally protected rights to seek a redress of grievances, exhaust administrative remedies, and conduct a common law court and self-determined Texas national status. After being sworn in as U.S. Attorney, Pam Bondi signed a memorandum creating a weaponized working group with the Department of Justice, and Trump appointed his pardon attorney, Edward Martin Jr., as director of the Weaponization Working Group to review prosecutorial abuses by the Department of Justice and its owned and operated Federal Bureau of Investigation. Recently, President Trump renamed the Department of Defense to what it was originally called, the War Department, and summoned all of the flag generals and flag officers of the Navy to the War Department for a briefing. And there were around 800 generals and flag officers at the meeting. Some of the points covered were that the Pope's owned and operated crown of the United Kingdom is a foreign enemy, and it's time to get focused on the fact that we are at war and the enemy was within the country. And the demand for one is ready to do whatever it takes to support that effort. Trump is only one guy. We need to be doing what we can to expose wrongdoing and bring it to justice. It's not the function of our government to keep the citizen from falling into error. It's the function of the citizen to keep the government from falling into error. And that's American Communications Association versus Dowd's U.S. Supreme Court. Anyways, I don't know if I want to go into the remedies. We could, I suppose. We'll go into it. 3 felonies charged against the demandant have been dismissed, evidencing their malicious nature, and should be expunged, as well as all the charges against all of those on the common law jury. There are many cases with possible relief in the matter. There's a recent case, Rab versus Ocean City, that awards $10,000 a minute, and there's Trevezant versus City of Tampa, where they award $23,000 for each 23-minute minute in 1979, almost 50 years ago. The demandant is not a liar and has no idea what's reasonable, but is asking for $600 million because it's going on for 20 years. The demandant leaves it up to the judgment of the court to decide the compensation. But the demandant is entitled to a remedy, and this is Article 29 of the Geneva Convention. The party to the conflict in whose hands protected persons may be is responsible for the treatment accorded to them by its agents, irrespective of any individual responsibility which may be incurred. Anyways, so I don't know that we're going to go through all this.
Your list of exhibits must be very big.
There's 17, I think, or 18, something like that. 19.
Rocco posted that case. I'm not sure where he put it, but he posted the case that you mentioned regarding Franklin State versus State.
Oh, thank you. Somebody sent me a super chat. Thanks. Well, this hasn't been. This is an amended. I'm answering some questions on YouTube. This has not. This is. I filed the original lawsuit, but this is an amended one, and I get to file one amended one, and after that, it's hard to say. I might not get to file an amendment again after that. But I get to file one amended one, and so this is an amended one. I wanted to get it filed as quick as possible, and then I knew I could do an amendment, so this is going to be the amended one. But I haven't even affected service yet, so I got to affect service. I got to wait at least until they respond the first time, and then once they respond the first time, then it'll probably precipitate some changes, so. Yeah, so this is just a Word file. I wasn't planning on making it available, but I understand that there might be some court cases and stuff in there that you're interested in. But it's going to change. It's going to change for sure. Yeah, there's going to be changes to it. Thanks for the donation, though. Anyways, I suppose that's about it. It's been going on for 2.5 hours now, so I think we should wrap it up. Does anybody have any questions they want to ask? I just asked a couple questions on YouTube.
Yeah. May I? Would you please post this? I always ask the same question. I don't see where you're reading this from, and I just stepped in. I forgot today was Friday. I was just busy working on my case. I love you, Glenn. Thank you for sharing.
Okay. I'll upload the Word file. I'll put it on the WeRLaw group. So on YouTube you can get it. You have to go to WeRLaw group on Telegram. It'll be on there. And on my room, I've got a room with my name basically. So you can get it there if you want to get it. The Word file. It's going to change anyways. I don't suppose it matters. There's probably court cases and stuff in there that you might like. But yeah, it'll be on the Telegram group. I'll put it on my page on Telegram. Maybe I'll do that while we're talking. Well, see if anybody's coming up with anything else. And what's the date today? 5 December. So it might be, I'm putting the date on it because, it's going to change. And so that's just what it is today. That's all it is. Just what it is today. And the fifth is going to be over in about 10 minutes.
I was going to say it's the 5th to the 6th till midnight.
Yeah. Well, here I'm in Texas and it's 10 minutes to 12 in Texas. That's Central Time. So if you're on the East Coast, it's already after midnight, and you're anywhere else, it's more than 10 minutes. Anyways, if that's it, I guess we'll sign off till next week. Same time, same place, same channel. And I'll keep you posted about my Supreme Court petition. So far they haven't sent anything back. I'm kind of excited about it, but I got 120 days. I have 4 months to file my petition for writ of certiorari. So I'm hoping they either at least send me it back or send me a docketing letter. They haven't sent either, and so if it gets to be like getting close to 4 months, then I'll probably have to just go ahead and do a regular petition for writ of certiorari. But I was planning on using that stuff, so now I got to make a lot more copies than I would otherwise have to make. But anyway, so I guess we'll see.
Because you're going to... Sorry, John, go ahead.
No, you can go first. I was just going to ask, but was that one word mammon? Did I hear you use mammon? And if so, how do you spell mammon or mannon? Or was it, did I hear it wrong?
I don't remember using mammon.
Mammon.
Okay. Well, thank you for the bold and honest and eye-opening educational testimony you shared.
Yeah, no problem.
Just going to say that mammon is in the Bible. It's M-A-M-M-O-N. M-A-M-M-O-N. 2 M's.
Right.
Mary.
Okay.
Mm-hmm. It's in the Bible.
Okay, well, if that's it, then I guess we'll sign out, and we'll see you guys next week. Same time, same place, same channel.
Yeah, I'm out of bad jokes for the night, so I guess.
I got a joke. Why did the chicken cross the road?
Mary
was a traitor, a British accredited regent in disguise. And that's the only way he could cross the road.
Yeah, something that I'm going to bring up. I got to put it in there. I got to figure out where to put it. But about the bar, in the definitive treaty of peace, a friend of mine just pointed this out. This is a friend that is very. He's kind of like my little group. Anyways, he pointed this out. Let me go find it.
Question while you're looking. Do you have a Facebook group? And if so, could you please share the link on your Telegram page, please?
I'm not on Facebook at all.
What group were you speaking about?
It's just a group of people that I network with.
In Texas, in person.
Well, he's actually this guy is actually in New Jersey. When I go to do my Northeast oh, here it is.
Oh, that's Nelson.
Yeah, it is Nelson. Yeah, you're right. Here we go. Here we go. It says in the definitive treaty of peace. Matter of fact.
Does that apply into my homeland?
It says in the definitive treaty of peace. Well, first of all, if you go to the treaty collection, the U.S. treaty collection, the only Article 1 of the definitive treaty of peace is still in effect. But in Article 1, it says that here we go. Article 1. It says, His Britannic Majesty said United States, in other words, New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia to be free and independent states, that he treats with them as such, and for himself and his heirs and successors relinquishes all claims to the government propriety. Okay? And when they're talking, this friend of mine points out that government propriety means private business, okay, and territorial rights of the same and every part thereof. So the government propriety includes the bar, okay? And so I was going to add in, I'm challenging the National Bar Foundation. So if I have to do if I have to do a petition for writ of certiorari, if they wind up sending that petition back and I have to do another one, then this is one thing I'm going to add in about the bar, because they're violating the Article 1 of the Definitive Treaty of Peace, which is the supreme law of the land. The Crown is not supposed to be here, and they are here with the bar.
It reminds me of that office. You heard of the Office of Unauthorized Practice of Law in Washington?
Yeah, exactly. They got no business being here. That's the bar, the National Bar Foundation. That's all the Vatican. That's the Pope. That's the Crown.
I got that written on my whiteboard. It's PROPIA, EMPROPIA, proper, and it's like that. The priory of the church. The priors. Do you have any priors? These are all Vatican Church vernacular, and it shouldn't be in these states. Oh, and I got another question. I see that you have the Republic of Texas. I live in Illinois, on Illinois. What would I call the state that I live on? As far as like you call yours the Republic of Texas. What would because I already started reading the top of your document. Very nice, by the way. What would I call Illinois? I know it was a part of the Northwest Ordinance, but I don't know what to call it.
Yeah, you're right. And the Northwest Ordinance is really powerful. I would definitely be claiming all the rights in the Northwest Ordinance. It's hard for them to weasel out of that, especially if I was in Illinois. But you could call it the Illinois Republic if you want, or you could call it Illinois State. Either one of those would be fine. It would be fine for sure. But the reason I use the Republic of Texas is because everybody knows the Republic of Texas existed.
Thank you kindly. I appreciate you. Thank you.
All right. Well, I suppose we'll call it quits.
Yeah,
Thanks,
it must
everybody.
be over midnight then. It's only
Sorry?
quarter. It must be over past midnight there, but it's only
2 minutes to 2 minutes to 12, and it's gonna be St. Nicholas. So leave your socks out, your little shoe. Maybe you'll get a piece of coal, and it could be with the right amount of pressure shoved up the right orifice, your diamond in the rough. Oh my God.
There we
All
go.
right.
I need one of those. Take care, Glenn. We'll see you next week. Don't be late, eh?
You bet. See ya.
Bye.